Characterizing the action in rem in Australia. Recent perspective. In a recent Australian Federal Court decision, Commanded Marine versus Pan Shipping 2006, it was observed that the theoretical foundation of the action in rem in Australia were not to be aligned with either one of two opposing conceptual approaches. This paper concludes that retaining such a measure of conceptual flexibility in the conceptualization of the action in rem avoid many of the problems and complexities that may arise if conceptual dogma, unfounded on any reasonable ground, is allowed to obstruct commercial expediency. Admiralty jurisdiction evokes, as Sir Ninian Stephen noted, a romantic sense of the high seas and that which is exotic. But in the modern international economy, this field of law has the function of being an integral part in facilitating maritime commerce and international trade. The history of this body of law is vast, intricate, and interesting. In Australia, the Admiralty Act 1988 formed the foundation of the exercise of the Admiralty jurisdiction by federal court. The Admiralty jurisdiction of state and federal court under the Admiralty Act 1988 is substantially concurrent. One of the consequences of grounding admiralty law in legislation has been the creation of an entirely novel form of action known as the statutory right of action in rem. This paper is concerned with the characterization of this particular legal action in the body of Australian law. In a recent decision handed down by the full bench of the Federal Court of Australia, Commanded Marine Corporation versus Pan Australia Shipping Pty Ltd 2006, the importance of Admiralty law to the operation of international commercial transactions was highlighted. One of the fundamental issues that arose in that case related to the law governing international commercial arbitration in Australia and whether a party to an agreement encompassing an arbitration clause would be deemed to have waived their right to arbitrate by proceeding to initiate a statutory action in rem. The point to be answered was, would the commencement of a statutory action in rem amount to waiver under the International Arbitration Act 1974? In addressing this issue, Al sub G, who delivered the leading judgment, was required to address how an action in rem was to be conceived between the disputing parties. Was it merely a procedural action meant to compel appearance before the court of the relevant party, or was it actually an action against a ship? In Australia, the difference between a right to an action in rem and a right to an in personam action is rarely observed. This lack of clear characterization in Australia may be due to the fact that underlying nearly all action in rem are in personam claim whereby the in rem action is utilized as a procedural means of compelling a person to front a competent judicial body to answer to the in personam claim. Justice Alsop ultimately observed that the theoretical foundation of the action in rem in Australia were not to be aligned with either one of two opposing conceptual approaches. Such an approach retained a flexibility in the conceptualization of the action in rem. This approach, it is here submitted, provides a prudent legal basis for understanding the action in rem. Such an approach avoids many of the problems and complexities that may arise if conceptual dogma is allowed to obstruct commercial expediency. This is exemplified in the context of international commercial RP. The action in rem and the Admiralty jurisdiction in Australia. An Australian admiralty jurisdiction, the action in rem is a form of legal action brought against a ship or property, as opposed to the action in personam, which is against an individual. The action in rem has a long history in the administration of admiralty law in England that stretches back over 500 years. In that time, this particular form of action has been given legislative expression on a number of occasions. After a period of marginalization by the common law court, the admiralty jurisdiction began to again expand in the mid-19th century. In the lead-up to the judicature reform, the jurisdiction of the common law court was progressively reduced, giving scope for the revival of admiralty law. The present manifestation of admiralty law in the body of Australian law is largely a result of the recommendation of the Australian Law Reform Commission, or ALRC, report number 33, completed in 1986. The ALRC recommended that the general jurisdiction of admiralty and the action in rem be retained as a distinct body of rules, as it has given rise to international business expectation, arrangement, and practices that rely on the fact that jurisdiction will be exerted over ships and ship owners in special ways. The end result of the ALRC inquiry and report was the enactment of the Admiralty Act 1988. Under Section 76.3 of the Australian Constitution of the Commonwealth, Parliament was given the power to confer upon the judiciary the Admiralty and maritime jurisdiction. Yet the exercise of this power by Australian court up until 1988 was based solely upon the empowering provision of the Colonial Court of Admiralty Act 1890. The Admiralty Act 1988 thus created a uniquely Australian framework for the exercise of admiralty jurisdiction by Australian court. The way in which the Admiralty Act has shaped this body of rules is by recognizing two types of maritime claims, those which can be classified as proprietary and those classified as general. Proprietary maritime claims are those claims relating to possession of a ship, title or ownership of a ship, mortgage of a ship, or mortgage of a ship's freight. In contrast to the limited head identified as proprietary maritime claims, heads are identified as giving rise to a general maritime claim. In the category of general maritime claims come such things as, among others, damage done by a ship to property, liability arising from pollution caused by a ship, claims arising from loss of life or personal injury, claims to loss or damage of goods being carried, and wage claim by a ship crew or master. The Act applies to all maritime claims irrespective of where the claim arose. Section 9 and 10 of the Act distinguish between action in rem and in personam. Furthermore, all proprietary maritime claims made under the Act can be commenced in rem. Section 14 of the legislation also provides that action in rem can only be brought under the Act. The section reads, "In a matter of admiralty or maritime jurisdiction, a proceeding shall not be commenced as an action in rem against a ship or other property except as provided by this Act." Apart from the distinction made between maritime claims as falling within the categories of being either proprietary or general, the Act also independently distinguishes maritime claim in another manner. Claims can also be classified as those claims capable of giving rise to a maritime lien and those claims subsisting as statutory right of action in rem. A maritime lien carries tremendous strength in the context of priorities as to competing claims. The strength of the maritime lien trumps all competing claims except earlier subsisting maritime lien that had previously attached to a vessel. A maritime lien is defined by White as a privileged claim, human maritime property for service rendered to it or damage done by it, occurring from the moment of the event out of which the cause of action arises, traveling with the property secretly and unconditionally and enforced by an action in rem. Thank you.